Thank you, my Lord. Lord, throughout this inquest, evidence has been heard of a shocking nature and which clearly does not paint a very good picture in relation to the security police and John Vorster Square at the time of this incident. And I'm not trying to defend that by presenting these arguments and by stating that one cannot forget the time of our history when this happened, the politically and otherwise. And what springs to mind is the rhetoric that was used of the rooi gevaar, the red danger. My Lord, but there can never be any justification for abuse of power or the disregard of people's integrity, the right to life. And there can be no justification to defend an apartheid era through police brutality. But having said that, my Lord, we must apply the law and the legal principles to these facts and to ensure that through these proceedings due process is followed and that due consideration is given to the evidence and the probative value of this evidence. Although I do not intend reading my heads, as I believe it is quite thorough and I have dealt with all aspects, but there are certain issues which I need to raise and which I need to highlight. My Lord, one of these issues I deal with under the heading of medical evidence. And my Lord, that is in relation to expert witnesses and expert testimony that the court heard here from Dr. Naidu and Dr. Holler. My Lord, I've referred your Lordship to the prevailing legal principles, and I'm quite sure that I do not need to repeat that. But in this regard, I must refer your Lordship to the fact that Dr. Skeepers is the person who saw the body of Mr. Timol after the fall. And present at that stage during the inquest was Dr. Gluckman. Now, Dr. Gluckman is not just an ordinary witness. He was the top private pathologist at that stage, appointed by the family of Mr. Timol. And my Lord, he testified specifically of what the intention was with his presence during the inquest, during the post-mortem proceedings. And I referred there to in paragraph 29.7, where he said his intention was to determine whether or not this man, Timol, sustained injuries prior to death. In other words, that was the reason why he was there. My Lord, and if one then continues on his testimony and one sees that he says that none of the fractures or serious injuries on the body of Timol was not consistent with being caused by the fall. That was his evidence. With that being said, my Lord, I believe that the evidence of Dr. Skeepers with Dr. Gluckman indicates definitely, and I will not hesitate to confirm that that is my reading of the evidence, that Mr. Timol did endure a physical abuse prior to his death. That evidence is clear. I cannot even start to try and refute that. And correctly noticed earlier in this arguments of today that the argument goes in relation to the seriousness of those injuries. And that is where I do have a problem with the evidence of Dr. Naidu and Dr. Holland. And that is where my submission is that they venture onto the realm of speculation and conjecture, where they impute evidence which is not based in fact, and use that as a as a basis for their expert opinion. My Lord, there is no other description of these injuries than within Dr. Skeepers and Dr. Gluckman, apart from the photographs. And the photographs at best can be described as faded, fuzzy photographs, and which even doesn't display all the injuries on the body of Mr. Timol. And for that reason, my Lord, it is extremely difficult and risky to try and interpret based on these issues. And now we look at the issues where the witness who describes these wounds and these injuries states that these injuries are consistent with a fall. And then you want to use that description of the injuries to say, but it's not. For example, fractures. If one deals merely just with fractures, and we know that the evidence basically from the witnesses that testified here is that Timol must have had a jaw fracture, the depressed skull fracture, as well as the left ankle fracture prior to the fall.
How did Skeepers opine on those injuries? What was Skeepers' view on those injuries?
Skeepers testified that he said, and that is contained in paragraph 29.5 of my head. He says, he held the opinion that he observed no old injuries on Timol's body that were not consistent with a fall and of a serious nature. That is what he referred to, and if I can refer or that would be...
Yes, but on the report, the post-mortem report, this is what he said in evidence.
Yes.
The post-mortem report, didn't he outline the injuries he had observed as not being consistent with the fall?
Yes, but he did.
Yes.
But these were not serious. But he describes that injuries as being not serious. He doesn't say it's not, that it was not inflicted, or that but it was not serious. It was not life-threatening. Certainly, if Mr. Timol had sustained a depressed fracture prior to the fall, which was of such a serious nature that he would have been unconscious, that is something that one would have expected that either Dr. Skeepers or Dr. Gluckman would have picked up when they saw the body and when they actually inspected the body, specifically Dr. Gluckman, when he says that was my duty there, that is the reason for me being present at the post-mortem, is to assess whether or not there were injuries that were pre-fall. And my Lord, basic principles in regard to reliability of evidence will dominate and dictate that one looks at the witness's evidence and description who actually observed these wounds as the more reliable evidence in this regard.
Well, the difficulty with their evidence is when they were placed under cross-examination, there were aspects where they departed from their original view as to what happened, from evidence in chief to that, particularly when the court was debating the question of the age, if I may say so, of the wounds.
Yes.
How old were the wounds? There was a change in Skeepers. Originally he said something, and then thereafter he said another.
Yes, my Lord. It went from 5 to 8 days to 4 to 6 days. That is the difference in the evidence. And
now, how can I rely on that? How reliable is that? If I were to take a witness who shifts position from the evidence in chief under cross-examination, can I really say that that evidence of such a person is more reliable than one who just gave an opinion based on the reading of a post-mortem?
yes, my Lord, but certainly in these instances, and we've heard also from the recent witnesses, that aging a wound is a very speculative issue at best.
Yes.
That the histology that was presented to Professor Koch for determination of the age of the wound, and one will notice that Professor Koch is even more resilient in the initial finding of the age of the wound than Dr. Skeepers. Dr. Skeepers more readily conceded that it might be one day this side and one day that side. Yes. And for me, it is not that is not a issue of his, for him being a good witness or not. It is, he actually conceded when one expected him to concede. And that is what one expects from a witness who is truthful and honest when he's confronted with possible scenarios or alternatives, that he will be big enough to say, yes, I've listened to what you say, and it might be this or it might be that. And that concession by Dr. Skeepers, most definitely, I will argue, and it is my contention, is not the indication that he is a lying witness or that he is prepared to change his evidence. He's prepared to concede when it is necessary for him to concede.
But nevertheless, the histology you are pointing out would give an impression that it was an area of speculation for everyone. Conjecture, because you have pointed out that there is no exact science that will assist to measure the age of the wounds. And if that is the case, then all of them were involved in speculation.
Yes, but
because I'm going to find it difficult to accept the submission that Dr. Holland and Naidu are speculating, and the other two were not speculating. I don't understand your submission on
that. No, my Lord, with great respect. What I'm trying to convey to your Lordship is that one cannot have no respect or no... you cannot ignore the fact that these two pathologists actually inspected the body. They saw the injuries firsthand. They have described the injuries firsthand. They made a conclusion on the injuries firsthand. And one should remember one thing when one considers expert evidence. It is not for the witness to make a finding. He gives an opinion, and it is for the court to make the finding. And for that reason, my Lord, what I'm saying is that the best evidence available here, in this instance, 46 years after the event, the best evidence available is the evidence of Dr. Gluckman and Dr. Skeepers, because they have the best perception and they have the best experience with the facts as they were 46 years ago. And I'm not trying to say that Dr. Naidu and Dr. Holland's evidence is of no value and that the court should disregard it. And your Lordship will see there is one issue, one of the matters that I referred to your Lordship is specifically whether evidence is reliable, not reliable, whether it's false, whether it's not false. In the end of the day, the court has to look at all the evidence, the conspectus of evidence, when it makes its finding. And one of the important issues that in an inquest, Lord, is that this is not neither criminal nor civil matter. The court just has to be prima facie satisfied.
Yes.
And that is a very, I want to say, a very light onus. It's not an onus, but it is not the insurmountable onus, if your Lordship will follow me in this regard. And from this perspective, the court must look at what is the veracity of the evidence, but also the likeliness or the probabilities on these evidence. Okay. And certainly I do not for one moment say that the evidence of Dr. Gluckman and Dr. Skeepers were perfect. It's not. Neither is their report. But what is, my Lord? Yeah. I'm just saying that the court cannot ignore the fact that Dr. Gluckman, especially Dr. Gluckman, was appointed to look at these issues. And one must also remember when the evidence was cross-examined and tested, and the veracity also of Dr. Skeepers' evidence was tested, we had the family represented by the top legal minds of the time. And their approach in the case at 45 years ago in that inquest, 1972, were within the moment, within the moment. They were living it. They were there. The witnesses were available. And unfortunately, and for reasons we will not know, if the record was fully available, one would have been able to see what the cross-examination, for example, was in relation to the other witnesses. And that would have been of great assistance to the court. But it's not to be. And that leaves a lot of questions, which the court now have to fill in gaps, unfortunately, because that's the reality of this time lapse, is that there are questions, and there are more questions than answers. And when one fill in that gaps, my Lord, it is my respectful submission, one must be very careful not to fill in the gaps in order to attain a certain end result, but that one should look at the probabilities of the evidence, but in a fashion where one say that, well, this is possible and that is possible. And eventually, when I get to my end of my argument, Your Lordship will see that what I say is that I think it will be inconclusive, because of the fact that that in order to answer all these questions that are there, one unfortunately have to speculate on some issues, and speculation is very dangerous.
Well, but we can rest assured the court is not going to speculate.
My Lord, no. My Lord, I'm pointing out the dangers thereof. I have got no doubt in Your Lordship's ability to assess this matter, and with great respect, my Lord, that is not what I imply, my Lord.
For example, on the question of assault, there's no way I'm going to speculate.
No, my Lord, you don't have to.
The evidence is quite clear.
No, my Lord, you don't have to.
Even the court itself of the first instance recognized that there were injuries that were on the body.
My Lord, you will see I refer to two instances of Dr. Kemp. Dr. Kemp with regard to Professor Nike and with regard to Dr. Essop indicated that there were injuries. With regard to Professor Nike, he said that this man is in need of assistance due to the paralyzation of his arms. And he arranged that there should be medical assistance. Dr. Kemp, in regard to Dr. Essop, listed 11 injuries on Dr. Essop's body, which he listed for purposes. There might have been more. I don't.
You recall with the evidence of Dr. Kemp that the judges were not happy with the way in which they had to extract that evidence from him.
Yes.
He wasn't really forthcoming, and we cannot really say that he was playing open cards with the two judges that presided.
Except, my Lord, and that is for the purposes of today. He confirms that there were assaults. And that is why I, as representing the implicated police officers, will not be doing my duty as an officer of the court if I were to argue in relation that there were no assaults.
Yes, yes.
I think that is a staggered evidence which I cannot argue away.
When he declared Mr. Timol dead, did he make any note of the fact that he has seen these injuries? That were, because he was the first doctor on the scene, yes, according to the evidence of the police.
But Lord,
first, he did not note the time of death,
yes,
which put Dr. Skeppers in a bit of a difficult situation. And it puts this court in particular in a very, very difficult position in light of the evidence that came in. We don't know the time of death. He didn't assist us on that. And secondly, the injuries that were on the body. You know, I don't know whether he really examined the body or he just went there, declared dead, and then moved on. I don't know what role he played, but...
I can't help the court there.
Yes.
All I can say is I would have also expected that in a report, yes, specifically if there were at that stage funny or strange yes, injuries, yes, or any indication which might have confirmed the time.
Yes, yes, proceed.
Lord, I've dealt with basically in regard to the expert evidence. I've dealt with that and I've raised the issues more fully than what I've addressed now. And also then, if I can go to my next heading, which deals with the allegation of assault and torture.
Yes, but
Your Lord,
before you leave the medical evidence, you'll recall that your witness, Mr. Rodrigues, was asked the question whether he saw any injuries on Timol, and he said no. There were no injuries. And when I questioned him on that score, he changed and said, well, my memory is failing me, I can't remember.
Yes. Your Lordship will remember what he said as well is that Timol was fully clothed. So,
well, there is an injury that they've recorded on the eye.
Yes.
He could not have been fully clothed there.
Yes, but once again, we're going...
He could have seen it. And if we accept that there were those injuries, then it raises very serious questions about his version.
Yes, my Lord, when we... well, Mr. Rodriguez's version is something that I will get to, but
yes,
it is difficult.
I'd like to hear you on that.
It is, my Lord, and one have difficulty, Lord, in reconstructing a situation 46 years later, Lord. It is, and I know the simple truth is that if it is the truth, it stays the truth regardless of the time. My Lord, but that is his evidence.
Yes, I hear you.
That is his evidence.
I hear you.
But Lord, if one then bears in mind, under the heading of torture and assault, I've dealt with the various allegations by the witnesses before the court, as well as Paul Erasmus and Dan Vorster. And it seems that there is a pattern of assault, and there is a pattern of torture, which is replicated there, and that makes it difficult for me. And the problem that I do sit with as a legal representative on behalf of police officers is that I'm hamstringed because these witnesses that would have been able to give me instructions in this regard are no longer alive. Yes. I can only follow the instructions of my witnesses that are here and are alive. And that basis basically my camp, if I can call it my camp without associating myself with the camp, in a big disadvantage is that if Captain Gloy and Van Niekerk was available here and they could have stood in that witness stand, my Lord, we could have extracted the real truth perhaps, I do not know. Yes. But it would have been a different situation whereby now, for me to deny assaults by a dead person, which allegation of assault reoccurs over and over in various documentation, I cannot do that.
Yes, I had a difficulty with the three of them, saying that they don't know about assaults except what they read in the media. All three said that. And I've just received about 5 affidavits which point out that Mr. Sons was not candid with this court, that he was involved in detention of some people whom he assaulted. So I don't know whether the evidence was rehearsed somewhere else or whether it was a standard response that they were taught to give. But is it a coincidence really that all three of them would stake the media as their source of assault?
Lord,
what do I do with that evidence? I mean,
with a little bit of background in criminal law and criminal prosecutions and defending people, my Lord, I don't find it so strange. People do defend themselves by whatever means if the screws are put on them. And I've never met a guilty person in prison.
Including misleading the court, and it's not good. I mean, for example, Rodrigues was not even accused of assaulting Mr. Timol. He was just asked a simple question: do you know that there are assaults that are taking place on detainees?
Yes, my Lord, but it
all out he refused.
But it all have implications for him, my Lord. Yes. It is almost being caught between the devil and the deep blue sea. If you know about the assault, you were complicit with the assault, and you were perpetuating an assault on detainees. If you deny the assault, then you're lying, and therefore you are guilty of assault on the detainees. It's a very precarious situation that he is in.
And he chose to lie.
But he made his choice.
Oh, yes.
He had the opportunity, and then he said, my Lord, he said here, with great respect, that this is the only truth. I will be lying if I say anything else. If that is his conviction, my Lord, that is his conviction. I can't change that, and I think...
Yeah, no, I don't expect you to change that.
From that perspective, if it's a credibility finding that the court will make, it will make that credibility finding. Yeah. But at this stage, when it comes once again, and I want to come back to the level of how certain you have to be to make a finding, and that's just prima facie, my Lord. And that's why an inquest is a very difficult situation to really ventilate a criminal case already in an inquest because of this low threshold that there is.
Yes. But then do I accept your submission that there were assaults on detainees?
But Lord, I cannot argue differently. As you will see, I made that concession.
Yes.
In my heads, I made that concession. Okay. Because that is what the evidence from all quarters say.
Yes. And on page 22, after that assault and torture, you mentioned time of death.
Yes, Lord.
Which is something that I'm very much interested in.
Yes. Lord, these are two complete opposite versions. Either somebody's lying here.
Yes.
And at the way that the witnesses, Token and Adams, testify, they were not prepared to concede that they make a mistake. My Lord, I have difficulty in understanding why time would have been an issue. Certainly if the police can sweep something under the table at 4, they can do it at 10. Lord, it is just of such a nature that, and this, the problem that I sit with, which the court is confronted here with, and which I have difficulty in arguing to your Lordship, is that we do not know what evidence might have been available in 1972 during that inquest in relation to the time. Because the issue of the time was never relevant, it was never raised, and I don't blame, but that it was just never an issue.
Well, the difficulty with that, you've heard Mr. Varney point out, that 46 years after the event, they were able, as a family, to do their own investigation, and they came out with these witnesses, something that the investigators at that time did not do. And that's the reason why such a thing may have escaped the attention of the court proceedings then. It did not do. And you see, the relevance of time, you have raised that thing that if there's a cover-up, it could have happened even around 4 o'clock. It's not only that. It's because Mr. Rodrigues stands by the 3 o'clock, 3:30, 4 o'clock version. And if he's found to have lied on that, my difficulty is which part of his evidence should I accept? And if I reject his entire evidence, the entire case of the police is built around that evidence.
Yes.
It falls flat.
Yes, but
that's the difficulty I have. That's why I say the time is significant in that instance.
Yes, my Lord, the problem goes further than that. If the court rejects Rodrigues' evidence,
yes,
and find that on probabilities this incident happened at mid-morning,
yes,
what evidence is left, my Lord, with regard to what happened to, then, my Lord, the whole issue with regard to what happened to Mr. Timol in room 1026, or on the roof for that matter, is based on inferences. And that inferences then can only be made on evidence that is found to be reliable evidence. And for a court to make that inferences, and your Lordship will see that I've referred to the well-known case of Blom, where my Lord, it states how inferences are to be arrived
yes.
at.
I'm familiar with the test in Blom.
Yes. So my Lord, as it stands in the inquest in 1972, there is a version as to what happened to Mr. Timol. If that version is rejected, there is no version as to what happened to Mr. Timol. I hear what your Lordship say, and your Lordship will see I deal with the issue of general, a finding of general liability on police members, unidentified police members, because your Lordship will also have noted that on the interrogation timesheets that were handed in here, from 8 o'clock the morning on the 27th of October, Captain Gloy and Captain Van Niekerk took over from Bauer, and I can't remember who the other officer was, but they took over the shift and they took over the care over Mr. Timol. So the one thing that is abundantly clear from the records, and which the court can most clearly find, is that from 8 o'clock until his death, Mr. Timol was in the care of Captain Gloy and Captain Van Niekerk.
That's the evidence that we can safely accept.
That is the evidence.
Even in their own version, they say so in their affidavits.
Yes.
Yes.
So that is the evidence one can accept.
Yes. What we don't have is what happened in that room at that time. That evidence we don't have.
If the if the version, as a possible version, is that whatever happened to Mr. Timol happened on the roof, that makes it more difficult because, well, there is no real evidence in this regard. And that scenario is, in fact, only really substantiated by Advocate Matters, who said that he looked up and he saw no window open. But Lord, with great respect, one must look at this evidence, and I will put that in the same bracket as the evidence of Adams and the evidence of Turkan, is that one should not bear or forget the fact that here are witnesses that basically remember and relive accounts that they have experienced 46 years ago without real connection with them, without real reason for them to remember the finer details. And that,
I wouldn't say so, Mr. Kutse. You'll recall that the witness, Adams, related the incident to the time at which he had to go and fetch his tea.
Yeah.
He was very emphatic on that one. You asked him even a question whether he went back to drink his tea, and he told you that it was cold. Yeah. He was very clear on that one, and I can't say that his memory failed him. But something that I cannot say about the other three witnesses.
Yes, my Lord, the one thing that one just must look at, is it reasonable to remember that?
Oh yes, it can be reasonable to remember things that happened even 50 years ago. If it's an incident that has not occurred several times in your life, it has impacted on you, how would you forget it? Well, Rodrigues was telling us about a story that General Bass wanted to influence him to do that, and he didn't say it 46 years ago, but he was able to remember it and tell us, yeah.
But it impacted on him directly, Lord. It was directly something that had to do with him. It had involved him personally. The fact that Mr. Adams' tea was cold, Lord.
Yes.
With great respect, that is a memory that I would not have expected somebody to remember.
Well, the evidence is not about the cold tea. The evidence is whether he witnessed a body.
But he linked that, my Lord. He linked those two to estimate the time.
Yes, he doesn't estimate the time. He says to you that it was my tea time.
Well, once again, as I referred to, your Lordship just have to be prima facie convinced about that, and then you can make a finding.
Yes. I cannot just dismiss the evidence because he's 46 years old. What would be the basis of that?
Yes, but one have to look at reliability and probative value of evidence, my Lord. And in that regard, the court makes an observation, but the court can also not just simply ignore facts, for example, the long duration of time.
But that line of reasoning, Mr. Kutse, is problematic. Many witnesses came here to testify about what happened 46 years back, starting with Dr. Esop, Dr. Jetam. Then you go on up until Mr. Casrels. They were all testifying about events preceding the death of Mr. Timol, or thereabout at that time. Now, your submission basically would be, if I use that as a criteria to accept or reject evidence, then all those witnesses could not have remembered, if I understand your
Lord, with great respect, then you must understand me. That is not what I said.
Yeah.
Lord, I would expect Dr. Esop, I would expect Dr. Jetham to remember exactly what happened to them.
And Mr. Casrels?
Mr. Casrels,
he has never met Mr. Timol, he said that.
Yes, my Lord, but...
So it did not affect him directly, but he remembered clearly what they were trained and what their position was.
Yes. Lord, that was something that they were physically involved in. They were involved in a struggle. They were involved in an ideology that they promoted through the struggle. And that was their life at that stage. That was their total commitment at that stage. And for them, I cannot equate the knowledge of Dr. Jetham about her assault to Mr. Adam on that day. Because what happened to her sticks in her mind. What happened to him to remember 46 years later that my tea was cold when I got back and I wanted new tea. My Lord, you cannot equate these two issues. Neither can you equate that to the evidence of Mr. Pahat or Casrals, because that was part of their life, and what they remember is their struggle, not their cold tea.
No, Mr. Pahat said that he was one of the last people to see Mr. Timol at the airport when he came to South Africa.
Yes, my lord. And as part and parcel of that, he knew him. For him, there's the reality of one of the people that he knew in the struggle and that he knew in exile and that he trained and that was involved with get killed. I would have expected him to remember that.
Well, Mr. Kutsi, I think you'll have to do much better than just say that because he's 46 years, I must disbelieve these witnesses.
Oh, but I can't do better than
yes,
that.
I don't think your submission is on point. Move on.
My lord, if I can then turn to, and I'm not rejecting the rest of my submissions, it is there for your lordship to read.
Yeah.
If one then bear in mind the evidence of Mr. Rodrigues, and my lord, one thing which I would submit to your lordship is that it seems clear that Mr. Rodrigues was an administrative officer in service of Compol in Pretoria. And that is a starting point from which one should evaluate his evidence. There's no indication that he's an operational officer or that he was in fact involved in the operational side of the security police. And bearing that in mind, it is highly unlikely that he would have been involved in anything other than administrative functions when he went to John Vorster Square. Now, if one rejects his version outright, then was he ever at John Vorster Square? Lord, that is the conundrum that the court is faced with. Is if one don't believe him, where do you stop believing him? Do you stop believing him that he was bringing a check and an envelope to Captain Gloy and Captain Funiker? Because for what other reason would he have been there?
If ever he was there.
If ever he was there.
Because that in itself, because you see, you remember when I questioned him, I said to him, you went into the corridor shouting, someone has jumped, Timol has jumped. But there's not a single witness that was called along that corridor to testify back then in 1972 to corroborate his presence there. Not one. And if you look at his affidavit and you look at that one of Dazen, he says, for example, that I went downstairs to the ground taking the lift with Colonel Greile. He says nothing about Dazen. And Dazel in turn says, I was told by Colonel Greile, I went and I rushed and I took a blanket and I went down the lift with Colonel Greile. There's no mention of Rodrigues. Now, you have to look at that evidence very, very closely. The question whether he was indeed there or he came in just as part of this story that he built, because no one is corroborating him on that story except Van Niekerk and Gloy. That's my difficulty with that. So the fact that he was working at Compol building, that is clear from his record, his file from that was brought by Brigadier Groeneval. That one we have. But on that particular day, whether he carried checks and all that, I don't know.
Lord, so far can I say, and that is not by the instruction from Mr. Rodrigues, I myself wondered about that, whether he was there. It came up to me as well, whether in fact he was there at John Vorster Square when this happened.
You see, the difficulty, Mr. Kusia, you'll know in law, once you say that this witness is talking the truth in regard to this part, and he's not talking the truth in regard to that other part of his evidence, you run into problems, because then unless you were there and you knew as a presiding officer, you are in no position to can say you are discredited in regard to part A of your evidence, but then part B, you are talking the truth. It's not possible.
But Lord, in this instance, and I do not say the necessary in all instances of a witness's evidence, but in this instance, I would argue to you it is an all or nothing situation. Yes. Either you believe Mr. Rodrigues,
yes,
or you reject his evidence in totality.
Yes.
And as I once again say, that's not necessarily in all instances where there's some discrepancies in witness, but in this instance, I think that would be the criteria.
Yes.
With regard to Mr. Els and Mr. Sons, there might be criticism. Mr. Els confirmed one thing for the court, and that is also why I cannot argue that people were not tortured. He does not consider sleep deprivation as torture, but I think with hindsight and with the knowledge that we have today, and also taking into account John Vorster's evidence, most definitely sleep deprivation is a form of torture,
yes,
and in that sense it is confirmed.
Well, he did not consider that. You are quite right. He was just denying the question of assault.
Yes.
First, he said he read it in the media, in the newspapers. And when pressed for answers, he changed and said, well, I might have heard some colleagues talk about it. That's what else said. Because in this particular instance, the focus is more on the torture, because that's the one that could have brought about those visible injuries on the body of Timol. But it doesn't exclude the fact that there may be other forms of torture which do not necessarily result in physical injuries. To be visible.
Manifestation. No, indeed so, my Lord. And in that sense, that's why I say I cannot argue differently.
Yes, I hear you.
My Lord, if one look at Seth Sons, my Lord, this is similar evidence against him, but he's not implicated directly. So for purposes of this discussion and for what we have today here, my Lord, and for what your decision has to be, apart from the fact that he might not be telling the truth on issues that has been raised, this is not for the court to decide currently whether or not Mr. Sons assaulted somebody else or not. And that issue was never put to him, and he did not have an opportunity to answer to that, although he was emphatic that he was not involved therewith. But he does not take your consideration closer to a decision with respect.
Well, it only conveys to this court that he was not candid. He was not honest with this court. I mean, he may not have had the opportunity to look at the evidence in the affidavits that were handed to me about the detainees he had assaulted. But he was confronted with the name of one particular detainee. Yeah. And then that's when he raised the defense that they raised all of them. My memory has rusted. You know, I can't remember. That's what I was hit with all the time here.
My Lord, under the other heading that I have here on paragraph 97, and that is the deceased members of the security branch, for whom I do not speak, but
which paragraph? No?
Paragraph 97.
If you skipped the others, I wanted to hear you on this cause of death.
On the cause of death, my Lord, yes. I
think page 24, paragraph 69, 70.
Yes.
What your view is here, especially in relation to the evidence of Moodley trajectory. Are you of the view that I should accept or reject that evidence?
My Lord, I understood the evidence, the oral evidence of Mr. Moodley here in court. And you will see I refer to it in paragraph 72 of my heads, and I refer to the place in the record.
Yes.
And I understood his evidence to say that Mr. Rodrigues' version was possible. Now, my Lord, maybe I read it wrong, but that is how I read.
That what? Sorry. You understood it what, in what way?
That he said that the version by Mr. Rodrigues was possible.
No.
That falls under the scenario, the scenario as set out in the third and the fourth scenario that he that he mentioned. My Lord, it is not clear. I do not for one moment say that it is clear what he said there, because he gave a very difficult answer to a question. My Lord, if your Lordship will just bear with me, technology will always fail me. My Lord, I've referred your Lordship to the reference, and for reasons unbeknown to me,
Well, you look at it again, Mr. Kutse. If you correct on that, you could write me a note and come back to me on it. I'll give you that latitude. But my understanding of it, he painted all possible scenarios.
Yes.
And in the end, he concluded that the story that he has jumped or dived out of the window is not consistent with the place where he fell.
I have in his evidence, his evidence under oath here, my Lord, at X, that is marked X, that is part of volume 9A that we received, and it's X, then brackets 673. He said the following: the Daisel version, I think, is possible if we knew what and if we had enough evidence of how the person left the body. If we had photographic evidence or something like that, it would have been possible, and so is Rodriguez's, based on the scenario that I put together. That is what he says, my Lord, and that's why I say, from my reading of this...
What particular scenario was he talking about?
My Lord, this was with reference to scenario 3 and 4 that he was discussing.
He concludes that, one, if it was a dive, he could have landed even 13 meters.
Yeah.
And then comes on and say that for him to land on where he landed now, he was certainly pushed. There was some force behind it, or thrown over. Then you say he took that to be consistent with the scenario of...
my Lord, I'm reading his evidence. I'm reading his evidence. What I read to you
I'll look at it.
His evidence. Your Lordship can look at it. And
you say it's page 673.
It's page 673 X673. It is very strangely numbered, my Lord, in okay. Volume 9A. It is not a continuous numbering.
I'll check because...
that. So I'm not going to address that, my Lordship. Your Lordship will look at that, and if you do not agree, that is my interpretation as to what he said.
Okay.
But I'll concede that it is not clear what he said there. But that is how I understood it, and obviously your Lordship will once again look at this. My Lord, but if we look at various scenarios, and one of the scenarios as to the cause of death that was put forward is the possibility of what I call the winter scenario, that he was dangling outside the window when he kicked, and that is from the Inside Boss reference on the book, and I deal with that. My Lord, the fact of that, and that is also a similar scenario as if he was on the roof and he was thrown and swinged and thrown over the roof. This street in front of the police station is quite busy. One see that even in that one photograph that was handed up with the plans photograph of the John Vorster Square at that stage. There are people walking there. And we know that at the dollar filling station there were people there. It is a busy part of town. To hang or to dangle a person out of a window, well, he would have been screaming. That would have drawn attention from the whole neighborhood, my Lord, and that in itself make it extremely unlikely. Similarly, if he was alive and he was well and he was being swinged over from the roof, one would have expected the risk of being seen. And why this is important, my Lord, is that this police station, and as we have seen, have got many sides, and there are much more obscure sides than the southern side if you want to throw somebody off the roof, where you can throw them off the roof. You don't have to do it in full view of Johannesburg.
Well, then it depends on the state in which he was. We just assume that he was in a position to scream. Yeah, that is, if I accept that submission, I must assume he was in that position, although the doctors now say that he could not have even ate comfortably with a broken jaw.
Yeah.
So there are many factors. You see, I'm going to stay away from speculation. I'm going to keep to the facts. There are many theories that one can come up with.
Yes.
And which would explain some of the things here. But in the absence of evidence, I will stay away from what you describe as speculation.
Yes, Lord, and that is exactly what I said over the page
Yes.
on paragraph 78, is that one should steer clear away from unsubstantiated speculation, and that is what your Lordship do. Lord, so that basically deals with the cause of death, my Lord. But Lord, then I deal with possible findings that the court can make. And in this regard, Lord, I first of all want to say that I'm in agreement that the court now and even in 1972 should not and could not necessarily have made a finding of suicide, Lord. It is a very difficult finding to make, even on reading the record. It is, Lord, but the scenario that I have...
But how difficult was it? I mean, the magistrate was given a story that the person jumped on his own, and he concluded that it was suicide, unassisted.
Yes. Lord, what I've tried to do is to set out for your Lordship a scenario which does not necessarily go to suicide, even if it is found that he might have jumped through the window, that it did not necessarily have to be suicide. Lord, and for that reason, and for the Mr. Caswell's evidence is quite important in that regard, where he says his then wife escaped from the security police under a ruse of going to a hospital. And most certainly that escape would have also involved risk. And if Mr. Timol was indeed assaulted to the extent that he was disorientated, and that he might not have known, if we look at the evidence, that he might have had a hood over his head for large portions of these interrogations, or whenever he's being moved in and out of offices, that he might not have been known where he was.
Well, that would contradict Rodrigues, because he said he found him sitting there on the table, looking at Loy and Van Niekerk.
Yes, Lord, but the scenario is one have to look at these things. And for him, even in that situation, and we've got Rodrigues' evidence that said that he just stared aimlessly in front of him, which could have been the stare of a disorientated person. I don't want to speculate, because I'm warning against speculation, my Lord, but all I'm saying is that even if he jumped, suicide is not the only inference that one can make. Even if one should find that he jumped through his own volition through the window, the only inference is not necessarily that he jumped in order to commit suicide. It might have been in order to escape. When he saw that these burly men from Wyk and Gloy left the building, they left him with an administrative person, that he might have summoned up the courage to escape, not realizing that he was on the 10th floor. And that is the only scenario in which I mentioned this, that if the court should, for whatever reason, find that he jumped through, that it does not necessarily mean that he jumped in order to commit suicide.
That's going to be hard to find.
But then,
because that evidence was not before the first inquest, it is not before me here, that he was escaping some kind of pressure or torture or anything. I don't have that evidence. So I won't make that kind of finding.
That's
no way.
But Lord, then I deal with certain issues, and my conclusion that I get to is that I'm not convinced that we can make a positive finding, or the court can make a positive finding, as to what exactly happened in room 1026, moments before the death of Mr. Timol. One can really make inferences as to what happened to it, but it is difficult, apart from those inferences, to say that Mr. Van Niekerk or Mr. Gloy murdered him in the office and threw him out of the window, or that they threw him out of the window whilst they were threatening him in trying to get him to talk. And if a court cannot make that finding, My respectful submission is that the court needs to bring out a conclusion which is inconclusive in saying that I do not necessarily know what happened there, but that Mr. Timol died whilst he was in the care of police officers, and more in particular in the police officers under the name of Van Niekerk and Gloy. That I can find. But as to what transpired there, I cannot make a finding, but I can refer it to the Attorney General to investigate.
I hear you.
Lord, may I just... Lord, I think I have used up my words. Thank you for the opportunity.
Thank you very much. I see you gave me a list of authorities here. I really appreciate it.
Thank you.
We have now come to the end of the proceedings. What is left for me is to go and consider this evidence that is before this court, as well as the evidence of the 1972 inquest. And I need to come back then with an answer to Section 16 of the Act. Section 16 specifically requires me to answer 4 questions. 1, the identity of the deceased. That is not in dispute. 2, the date of death. That also is not in dispute. 3, the cause of death of the deceased and the manner in which it occurred. The cause of death is not in dispute. All the doctors agree. But the circumstances are the area in which I need to go in. And the 4th question is whether any person can be held liable for that. And if so, I must refer to that person. So I'm going to be going into these aspects. And you said it, Mr. Varney, that you buried me with a mountain of paperwork. And that's the mountain I have to climb. And it's going to take quite a while, but certainly I'm going to try my best to do it within a very short period. If everything comes right, it might be before the end of this term. I will let you know of the date. I will give you lead time, and as soon as I have prepared it, I will give you lead time, all of you. But between now, and I can safely say between now and the end of week after next, if there is any written submission you wish to send through to me, you are welcome to do so. All 3 legal advisors and the representatives, you are welcome to do so. After that, I won't be able to accept anything because then I will be busy writing. Thank you very much. We are adjourned.